in a better way too, but without infringing the necessary quality for the intervention of the prosecutor, which should be present anywhere, anytime, at any stake.
I will speak in Portuguese. Boa tarde. Eu gostaria de saber como é que na Estónia utilizam a internet, uma vez que sabemos as potencialidades da internet e como a Estónia funciona grande parte dos sistemas públicos através da internet, como funcionam para melhorar a celeridade da justiça e o trabalho também dos procuradores. Para Roaldona, eu gostaria de saber a produção de prova em julgamentos na Holanda, que tipo de prova utilizam em julgamentos, designadamente se existe a necessidade de reproduzir os depoimentos das testemunhas novamente em julgamento ou se utilizam os depoimentos das testemunhas produzidos em fase de inquérito. Também tenho alguma curiosidade qual é a percentagem da utilização da imposição de sanções por parte do Ministério Público holandês. Muito obrigado.
Thank you for your question. Answering your question would be very simple if I had my laptop with me, but basically in Estonia we use a lot of digital signature. It means that all the documents that are signed by using your ID card or even your mobile phone are valid as legally signed documents. We have different computer systems, we have databases for criminal investigation. All the investigative acts are registered in this our information of criminal procedure. Whenever somebody begins criminal investigation, all is recorded to this database. Whenever somebody is questioned, everything can be recorded to the database. Whenever I, as a prosecutor, want to make a search warrant, for example, I can do it in my computer. I can upload it to the computer system, sign it digitally from Portugal, even if I want to. The document is sent to the judge or the police unit who is responsible for conducting the search. After the investigation is over, I can make the indictment in the computer and sign it with my digital ID. The document is sent directly to the court very quickly. So basically, most of the work, computer work and the written work of the prosecutor can be done out of office. Actually, I did some work when I was flying here. In the times of my connection, I just signed an important act of termination of criminal investigation. I sent it to another colleague, and termination of the criminal investigation is in power at the moment. So it was done in 10 minutes from the Brussels airport, and this is it.
And in regard on your question about hearing witnesses during court sessions, it's most common in Holland that the witnesses are heard by the police, and it's a written report which is sent to the courts. It's only in this very few number of cases where the defense lawyer normally asks for witnesses to be heard in court, and it's court who decides whether it's necessary to have the witness heard in court as well. But the majority of these requests are turned down by the courts because they say there's also already a written document which we think is sufficient to deal with. But of course there can also be new witnesses which haven't been heard by court, by court or by the police, proposed by the defense lawyer during the actual trial. And also sometimes experts, like forensic experts, are asked for by the defense lawyers to be stand as witnesses in trial. So it's not that all the witnesses are heard in court. 99% is, of course, done by, well, and at least in that situation, done by the police.
Good afternoon. My name is Veli Ünal from Turkey, the Council of Judges and Prosecutors. Thank you for your presentations and your answers. I want to ask a question to Mr. Dona about super fast lane for simple crimes. Which kind of crimes this system deals with, and do you have any information about the percentage of this kind of crimes compared to total number? Thank you very much.
I don't have any numbers, but it's the most common crimes like shoplifting, pickpocketing, burglaries, the simple crimes, which are, of course, the largest number of the minor offenses. So it's the crimes which doesn't need a big police investigation, but usually the cases will be clear after the suspect is brought to the police station and some interrogation has been done. So it's the crime on daily basis, like I mentioned.
Thank you.
Greetings from Turkey again. I'm Judge Hussein Cemeren from the Council. I would like to ask Mr. Dona also, you mentioned about accountability in your statement, the role of Minister of Justice. What is the exact role of the Minister of Justice? I mean, there's just a financial supervision, or there's an inspection of public prosecution service, or a disciplinary, is there a disciplinary issues? Thank you very much.
The role of the minister is laid down by law, as I told you, that there's no interference with individual cases, except for one exception, where he has to be totally transparent if he wants to give an order. For the rest, he's informed by the public prosecution service on the choices they make in the more severe cases, the more sensitive cases. For the rest, the public prosecution service works independently from the Minister of Justice, but the Dutch system, in all respects, is a system of consensus. We are a community where we cooperate, and there's always a lot of exchange of information and working cooperatively with each other. But it's a different, of course, because we are tax funded, he's accountable to Parliament for the way we spend our money, but it's not that he has influence on or directly controls the public prosecution service.
Well, thank you. I'm Vladimir Zemin, Senior Assistant to the Prosecutor General of the Russian Federation on special issues. And I'm very thankful to Mr. Han Moral for his question in relation to correlation between speedy process and fair process. It is a question in our country. Some 10 years ago, there was a summary procedure introduced in our country, but we noticed that in many cases, the accused person preferred this summary procedure when they were not guilty. But they say, well, yeah, we are guilty, and they were promised by minor punishment or so. I know that such a problem is many countries has such a problem, and we tried to react to this problem. Prosecutor General Office in our country has the power to coordinate activities of law enforcement against crimes, and Prosecutor General summoned chiefs of investigation agencies of our country and discussed this problem. In some regions, 60 or 70% of criminal cases were conducted as a summary procedure. And they thought that this is not a normal. And in many cases, it was established by prosecutor or even in the court proceedings that there were no grounds for summary procedure. In some instances, the accused persons didn't realize the consequences of their consent to summary procedure. And the Prosecutor General, after that meeting, with the participation of the representative of the Supreme Court, gave an instruction to prosecutors more thoroughly see to the materials, especially to the consent of the person to be tried in summary procedure. And a decision from the Supreme Court also was in that respect, which called on judges to analyze in the court proceedings the real situation with the consent of the person to summary proceedings, and if he realized legal consequences of that consent to be guilty. And another issue I'd like to ask, problematic issue, I suppose, the criteria to evaluation of the outcome of particular prosecutor and the prosecution service, maybe at regional level and so on. You know, for instance, there is such a criteria as crime rate. If there is a rise in the crime rate, in some instances our police are accused of negative outcome of their work. But some 25 years I worked in the Academy of the Ministry of the Interior, and our criminologists made a study, and they came to the conclusion that there are some 200 elements which are connected with the crime situation in the country. And police may influence only some 20 of these 200 elements to influence the situation, crime situation in the country. And police cannot be evaluated by the factor of crime rate by alone. And in relation to prosecutor, for instance, in our country, some 3 or 5% of the accused persons are acquitted by court. And our defense, our human rights protection organizations accused prosecutors and court of accusatorial approach. And they say, well, look at Western countries. There may be 15 or 20% of accused persons acquitted by the court. But we say that our prosecutors may be more attentive at the stage of checking the file before bringing it to court, and also in court proceedings. What is your opinion, and maybe your experience, in evaluating outcome of prosecutorial work in criminal justice? And I'd like to hear the answer from the chair and from the representative of the Dutch representative. Thank you.
To start with the first question, when you do a case in the ZSM procedure, as in the superfast lane, it's the task of the prosecutor to maintain the obliged level of quality. And from the moment a suspect is brought to the police station, he has the right to be assisted by a defense lawyer. So it's not, as I understood your question, a question of negotiation, that if you consent, you get a fast lane procedure. The police do their work in the way they should, with the defense lawyer assisting the defendant. And after they've done their work and they have done sufficient research, then it's transferred to the ZSM desk, and the prosecutor is, makes a decision together with the other institutions whether this case is suitable for this procedure. And as I heard you speaking about a summary procedure, I thought you mentioned that it was a procedure where not all the investigations has been done, but only a small amount, just to sort of negotiate to get a fast lane treatment. That's not the way the ZSM procedure works. The police do their work in the way they should, and the defense lawyer is always present if the defendant wants to, and it's the job for the prosecutor to maintain the level of quality we need. Because otherwise, as you said, if the cases go to court, in the end we will hear from the judge that the work hasn't been done properly. And the second question, it's always very difficult, I think, to see the effectiveness of the work of a prosecution service. The numbers of 15 or 20% of acquittal, I don't recognize, I don't have the exact figures, but since I'm a prosecutor myself and I'm going to court, it's not the number I recognize from my daily experience, the number of the percentage of acquittal. So, but I agree. There's so many factors which are involved when it goes to the effectiveness of the prosecution service. So you can't say that it's only up to the police or the prosecution service whether crime rates rise or whether they go down. So it's always difficult to say, I think, what the role of the prosecutor in that respect is.
The same goes for Estonia. Whenever somebody is sent to court in the speedy process, we have to gather evidence. The person has a right for a lawyer, and actually whenever we go to court, the judge has to approve the materials of the criminal case as well. They are not rubber stamps that are putting signatures on the court decision. They have to do the real work, everyday work. They have to seek through the documents, and they have to be sure that the person is really guilty of committing a crime. And actually it is a crime to make a false accusation of against another person in Estonia, so nobody would dare to send a person to court without any evidence, just based on the agreement to use the speedy trial against somebody. And what concerns giving an opinion about the prosecutor's work, the statistics of crime, in my opinion, isn't a good tool to rate the efficiency of the prosecutors. As I told you before, for example, domestic violence is a really huge issue in Estonia at the moment. The issue is addressed in newspapers, and actually the crime rate concerning domestic violence rose around 60% last year. And it wasn't because the people are getting more violent or the everyday situation is getting worse in Estonia. It's because we have made a lot of public, but we have given our public messages that you should go to police whenever you are beaten up by your husband or wife. You shouldn't be afraid of going to police, going to prosecutor's office, and now victims turn to us much more times than they did in the past because of the good examples of the prosecutions. So the crime rate doesn't show the picture that is happening actually in the field, in the streets or in the apartments.
Well, I just add something to what has been said about evaluation of prosecutors. It depends on the work of the prosecutor, of course. If you're dealing with criminal cases, the type of criteria that you have to meet are different from those that you will work with if you are in family law, juvenile justice, or otherwise. And the fact that, as in the case of domestic violence just cited, the fact that the public prosecutor interacts with other stakeholders, for instance, victim protection NGOs, or with the criminal investigation agencies, or with the public, or with other agents that could have an impact on the way of addressing this scourge, is indeed something to be commended. That's something for which the public prosecution should be also evaluated, not just to act in the court, but what he can do outside the court in order to have less files in the court at the end. No more questions? And I think we have finished. Probably the organization will like to announce what will... Okay. Thank you very much for your cooperation and help. And thank you for the panelists.